Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Always down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a Oh, you're still here. I didn't know if you'd left yet. I don't know what happened there. That was a full Creed frame. What I think happens to Creed when he Creed frames. Um, that was traumatic. I hope everybody's doing well. I am a little discombobulated because everything has been deleted, but that's okay. Will give me a minute to get that sorted. Let's, in the meantime, talk a little bit about dinner that we had today. I'd love to hear about dinner. If you didn't like what you had for dinner, go ahead and tell me what you wish you had for dinner. I see your comments. I'm not gonna click on them because that seemed to book some shit up last time. So I see them. Yes, I'm always gonna. No, I have my pen right here, and I'm just that's so weird. Anywho, give me one moment. You had nachos. Okay. Oh, and forgive me and thank you so much for obliging me on my quick departure last night. My sister is going on a trip. Went on a trip today and had needed some help with the baby while she packed everything. So I got like 6 hours uninterrupted baby time. Oh, it was so good. Look at me. I can't even stop pressing them, even though I want to. Stuffed shells. You're having stuffed shells too? Amy and Chuck? Do we not know something? Do you have something to tell us? Cole's here. You want to laugh? I will help you laugh. I don't know how yet. but we'll figure it out together. Chipotle's barbacoa burrito. You were not impressed. Did you film them while they prepared it? Is the question I have, Lucy, because that's a thing lately. That's a thing. 6 hours of cuddles. Seriously, delightful. I mean, I don't want to brag or anything, but it was perfect. It couldn't have gone better. I mean, I'm just thrilled. Yeah. And so and they're away now. So they are, there's no chance that they'll call again today. Unfortunately, they are now off and away on a little summer vacay with the baby. Yay, yay, FriYAY. Oh yeah, so last night we were watching Judge Vonda Bailey. She was really jiving with that judge. Oh, and they also got dinner for me. It was great. They're like, while you're holding the baby, do you want us to order you some dinner? We want to eat. I was like, yeah, I love that. Love that. I think Amy and Chuck are a thing. Yeah. That's what I heard, MB. Or that's what I deduced. Deduced. So a vacay with the baby that came from the vajayjay of my sister. Yay, yay. Oh, you got a call during court last night and worked all night. Well, I love babies, so it wasn't work for me, but some people would, I mean, charge. Uh, I mean, I'm just gonna say it. I made the baby laugh. I made the baby sleep. I made the baby burp. I made the baby eat. I sound like a little nursery rhyme. We read, we sang, we danced. It was a great time. But that's pretty much what you can expect if you ever meet me. There's also a fly in here now, and I'm bothered by it. But anyways, let me get something to put on for us. It's small claims court. I'll probably pre-frame right now, or it's going to be like the most solid situation ever. Also, I'm drinking Coca-Cola. Thank you, Coca-Cola. I don't know if I thank Coca-Cola enough. You know, for something that I drink a lot, I don't know if I thank them enough. Thank you, Coca-Cola. Appreciate you, baby. Oh, I have to put it on the stage. Dumbass Paisley. All right, and fast forward like 2 minutes. Oh, you did do some homework, P. Remember? Remember?
You went to the restroom.
Whoa.
You would raise.
Can you just calm down? Thank you. I know. I just mean personally. Like I like to be thankful and grateful for. Oh, Vicky, you're right. That's right. I didn't see that. Judge, hold on. Okay, so the buttons aren't working on there like they normally are, which is interesting, but whatever. Let's go to Vicky's. Yes, Vicky, I'm so thankful. I saw it right as I went live. Let me hit the thank you. Thank you. I love your new painted rock done by another member of the chat. So cool. Okay. Did I hear that Dr. Pepper Pepsi is the number 2 soda? No, I didn't. Did you know that in Scotland, where it was born, that Iron Brew, I think outsells KCC, which is rare, you know? Um, Hi, Wahoo. Okay. All right. I think we're caught up. I caught up on reading, showing. Let's get going. Wow, I'm really rhyming today. I don't know what's happening. Baby.
All right, Mr. Canada and Interstate Automotive.
No, I wouldn't call myself Mrs. Canada, Judge. Thank you. Maybe. I don't know. Is that what he just said, Mr. Canada? Didn't even capitalize it. It's your last name, sir, and a kind time. All right.
Yes, sir.
And looks like, I'm pretty sure you're not Robert Steffen.
No, he went to the restroom. Just hold on a sec. Robert.
Yes. Here. Sorry, sir.
All right, if both of you would raise your right hands for me, please. Swear the testimony in this case to be the truth, whole truth, nothing but the truth.
Yes, sir.
Yes, sir.
Okay, thank you.
No one's asking for a continuance.
All right, Mr. Canada, you're concerned about your Mazda pickup, and you allege that you took it into Interstate Automotive and they didn't complete repairs. I'm not sure what that means, and I'm sure you'll tell me. And it was an engine install. You were concerned about lack of communication, and that was one of the reasons I pointed out in our talk that that's not really an issue for me. The question is, what did you hire them to do? What did they do or not do? So, Mr. Canada, go ahead.
Well, in April, I delivered my vehicle, my 1998 Mazda B2500 pickup, to Interstate Auto for an engine replacement on the recommendation of Mr. Stephen. He had requested, after bringing it in, to have it diagnosed that it did need an engine replacement. And I had asked if that was something they could do or how to go about that repair. He had recommended that I get an engine through O'Reilly Auto Parts, which I did and had it delivered to their shop. After a couple of weeks, I called for an update on that and was given reasons why it hadn't been completed, that it needed an ECM, that it needed multiple other parts to run correctly. And so they took time for them to order their parts, which I understand, and to get them in. Once those were installed, the engine was still not operating correctly. And I kept calling every 2 weeks to request an update. And they gave me excuses as they hadn't had an opportunity to get to it because they were busy and shorthanded. And after 3 months of excuses, I had requested that all communications be an email from that point. So I had a record of communication between myself and the shop. And it ended up being that they just stopped working on my vehicle. In the time frame in which our last communication had taken place, I incurred $4,500 worth of rental fees. I lost out on several jobs because the vehicle is used in my work. And at this point, I'm not very confident that Interstate Auto is capable of actually making the repairs to the vehicle to make it safe and functional.
Okay, so right now, who has the vehicle?
Interstate Auto.
Okay. And
It sounds like we did this a year ago, you guys. I promise this is brand new. I swear to God, deja vu, because we hear this is literally word for word that same. The make of the car was different for that other guy. It was a Japanese car, right? The Mazda Japanese car. But anyways, it's not the same case. This is today. I promise.
was there a written contract or estimate?
I was provided an estimate, or not an estimate, a total of work performed totaling 6,100 or 6,000. Oh goodness, this is different. Let me see if I can find that particular email with all of that information. $6,152.41. They've had my vehicle for over a year. They state that they needed my final permission to continue work on the vehicle, which I had given them on July 12th of 2023, in which they responded thanks in an email. And now they're claiming that they need explicit permission from me to continue the work before I file a warranty claim against the company that had actually provided the engine.
Okay. So tell me what you're requesting, and your theory is that have they breached the contract?
Yes.
Wait, are you saying that this is the case, Loud, that we covered very similar facts? But can you do that? I thought that lawsuit handled that. I'm confused now. Let's keep watching Judge Wilhelm.
That's your position? You
Yes,
know,
sir.
And was time parties, did you say it, did they promise to have it done in 1 month, 1 week?
Initially, when I had dropped off the vehicle and I had asked, how long do you assume this will take? They said, oh, it should only take a few weeks.
And it's still not done?
That is correct, sir.
Okay.
That other case, they dropped it off in pieces at the other location, and he had all the pieces, but they couldn't put it together.
When they told you they needed something else from you, did you, even though you had provided something back in July, did you give them what they needed?
Well, the parts that they said the vehicle needed to operate properly, they ordered themselves. They sourced those parts and had procured them through their own business. Now,
Right,
I had given them permission to purchase those parts like the ECM. It looks like there was also a ignition coil and some form of something called a moto vacuum, which was fuel injector cleaning. Now, the vehicle did arrive under its own power when it was delivered to the shop. And so I have records that the ignition coils had just been replaced, not even a month prior to it being delivered. I don't really know if the fuel injectors were in optimal position or optimal functionality. But like I said, the vehicle was operating. It just had extremely high mileage when it was delivered to them.
Okay, and you were asking them to take out the engine that was there and to install a new engine? Is that what you were asking them to do?
Correct. That was on their recommendation, as
Right.
well as they recommended where I get the engine from.
Okay. And tell me, what about the job that Interstate Automotive has done that you believe makes them liable to you for any damages?
Well, it seems as though they claim that the engine has multiple issues, ranging from high oil pressure to leaks to running rough. Now, they've thrown, like I said, multiple parts at it, trying to get it to operate correctly, have ran up labor cost to over $6,000, and are still expecting me to either pay them for a job they have not completed or to give them permission, which had been given back in July of 2023, to continue work. I haven't heard from them in over a year in regards to this repair. I had requested specifically that all future communications from July 12th of 2023 be in writing. So I had some form of proof, because at that point, it had been 3 months of excuses of why my vehicle wasn't finished and why it wasn't safe and functional. I had been put off multiple times and had heard from their lips specifically that they just hadn't have the time to get to it because they were short-staffed.
Okay, but let's focus on what is the issue that they still have it and it's just taken longer than you thought, or the issue is you're not satisfied with the work they're doing? Let's figure out
Well,
what the.
I would
issue
say
is.
both. I would say both. It's taken far longer than it should have to replace an engine. And the work on their installation, apparently it still has problems. The engine still has problems. It's been sitting in their lot for over a year. And at this point, I don't have a lot of faith that these folks can actually do the job properly because they've been trying for gosh knows how long now.
Okay, but you don't have any specifics as to anything they've done to the engine which makes it not operate.
Well, all I know is that when it arrived from O'Reilly's, apparently it's a rebuilt engine. It arrived from them to them with 0 miles. So I don't know what has occurred to the engine while it's been in their possession.
Okay. All right, and it's Mr. Steffen, is that right?
Yes, sir.
All right, so Mr. Steffen, it sounds like the engine came in back in April 2023, is that right?
Yes, sir.
Okay, so here we are in June of 2024, and there's apparently a non-operable engine. Talk to me about your view as to whether that's appropriate or not appropriate.
Well, there wasn't a recommendation to get a motor. His motor is junk. So he brought the truck over here. He drove it over and it ran really, really bad. And he supplied his own engine from O'Reilly's. I normally always supply my own parts because if there is a potential warranty issue, I want to be able to deal directly with the warranty company. And now it's my motor. We don't have a problem. Just like you wouldn't bring food to a restaurant, complain about the steak or whatever. But so I put the motor in and the motor would not run right. Okay. So we found some other problems with the truck. The truck never ran right when I had it. And we fixed those problems. That I was the last one to correspond or talk to or email Chris. And I did not hear back from him. I sent him a detailed thing about the warranty company would not deal with me. They would only deal with him. And it was his responsibility to pay me for the warranty work, and then present that bill to the warranty company to get reimbursed for that. And it was about a year ago. I didn't hear back from him. Nothing. It just sat there. So I figured he just abandoned the vehicle like so many other vehicles get abandoned in my yard. And then I started a channeling deal, I don't know, a month or two ago. And as soon as I sent a channeling, then I get a thing in the mail a couple of days later about a small claims court case. So like I said, I don't like supplying or installing somebody else's parts because it comes into this problem a lot of times. And I was the last one to talk to him. He never responded back. It was until I responded to him a year later with a chattel lien deal to get title so I could get some money out of the truck that had been abandoned in my yard. So that's my story. And I feel sorry for him. It's a bad, it's a junk motor, and it's not like he did it on purpose, but he was trying to save some money by buying a motor himself, and that's not a normal practice with a shop, sir. So,
Okay, so when did you communicate with him all the different things that needed to happen to make it operable?
I sent him an email. It was almost a year ago, and extreme 6-page email about everything we had done, what we had done with the warranty company. A lot of time spent trying to get a hold of the warranty company, waiting for them to call back. I went down there. I spent many hours doing that. I don't charge for. And then I sent him that big email that he needs to give me permission to go further because they're not going to do it. They're not going to pay me. He has to pay me. And then in April 19th, I sent him another email, and he never responded back since. Until it was the first time I've talked to him today since April 19th when I emailed him about wanting to get this thing fixed. I figured he had just abandoned it because I was the last one to talk to him.
The 6-page email you sent was sent when?
I believe no. It was this one right here, 6-page.
It was 14 July.
You sure that was when it was sent? Oh, I'm talking to my lady who helps me with the internet here.
Yeah, because it just said X, remember, right there. 14
Not me,
July.
sir. I
Yeah,
can't help with the
14th of
internet.
July, 23 is what my
Okay.
records show.
And in there, you said what essentially to Mr. Canada?
Well, let me get the,
Last page.
no, that's not the one right here. That's the other one. Hold on, sorry about that, going through all this paper. There's one right here. Yeah. And and in the end, it said the warranty company will only deal with the engine purchaser. They say you were to pay me, and then you bill them. I ran every test I could to find the issue. Multiple non or incomplete combustion issues are involved. The motor's got internal problems beyond the parts I put on it to get the motor to run correctly. It still has an internal problem. What do you want to do? This is not my engine. Here's the number and name of the claim number. I started claim number 148426 and the phone number to address that. And I never heard back from him again until I got a small claims thing. So I just thought it was abandoned.
Okay.
And I like calling him, but he won't call me back. He wants to do email only. And my records show I was the last one to email him, sir.
Mr. Canada, anything you want to add to that?
He did actually recommend that I go through O'Reilly's. He said it would be much faster if I went that route because then they don't have to source the engine. So that is a complete falsehood. Now, he did email me on July 14th, like he said, but it wasn't a 6-page email that he sent. It was a 4-page email. Okay. And I can't go to the warranty company and request a refund on labor and parts to make an engine safe and functional until the repairs are done. He had received an email from me on the 12th, July 12th, 2023, stating, I am making this plain and clear. We are expecting you to complete the repair that is required to make the vehicle safe and functional. All future communications from here on out will be made through email. Please contact me when the repair is complete. From there on, nothing. All I had heard were excuses prior to that email in regards to we haven't had a chance to get to it, we're short-staffed, and every excuse that they could make under the sun. I called every week for 2 weeks, or every 2 weeks for 3 months, asking for an update, and nothing ever came of it. So like I said, I just don't have a whole lot of faith that this business is capable of diagnosing, locating, and actually making the repairs to make the vehicle safe and functional.
Okay. So when you heard back from Mr. Stefan that he's not the warrantor of the work, that in order to activate a warranty, he's going to have to do more work on the engine. He doesn't want to sink his money into it. So he's telling you basically you have to pay for more work on the engine, and then you're going to have to file the claim with O'Reilly's or whoever the insurer was there who was guaranteeing the engine. It sounds like that's where you two sort of split ways. You wanted him to just go ahead and finish it, and he's saying, I'm not going to put any more work into it until you start paying me. Is that sort of where this thing ended up?
No, he hadn't requested payment.
Yes.
He hadn't requested payment.
Okay, hold on.
At that point, I had said, you have to finish the repair before I can actually go to the warranty company to say, hey, this is the amount that it costs to put the engine in a safe and functional position. So you have to warranty this amount.
Okay, so were
He
you
threw
expecting
parts
to have
at it
to pay
and
Mr.
hoping to fix it?
Okay, hold on. So were you expecting to have to pay Mr. Stefan and then get reimbursed by the warrantor company? Or you were hoping just to get the final bill, give it to the warrantor company and have them send the check to Mr.
No,
Stefan?
I was planning on being responsible for the bill to Mr. Stephen, and then I go to the warranty company after such. because I can't go to them until I know exactly how much the repairs cost to put the engine in, functional position.
Okay. And Mr. Stefan, had Mr. Canada paid anything to you to this point?
He had paid nothing. I may also comment, part of staying in business is for me to buy my own parts, and I can access the motor out of O'Reilly's or whoever way faster than him anyway. They'll deal directly with the warranty company, and it's common practice at any shop to supply their own parts, not have the customer do it. And then I completed the job of the install, and the next step was the warranty issue, which I spent a lot of time on my own before I requested from him to get permission on a separate issue to pay me to go after this warranty issue that the warranty company wouldn't pay me. They said he had to pay me, and then he had to submit the bill to the warranty company after that. So I need to get it clear what really happened, sir.
Okay. So
he never gave me permission, and I'm not going to spend my. Oh, sorry about that.
You have the truck.
Yes, sir.
You sent him this email on the 14th of July last year. And did you tell him that you were, read something in there, did you tell him that you were waiting for something from him?
Yes, sir. Let me get to that page. It says here, I have found nothing to Interstate Auto. It says the warranty company will only deal with the engine purchaser, being Chris. They say you were to pay me and then bill them. I ran all these tests. I found nothing the Interstate Automotive has done wrong. What do you want me to do? This is not my engine. Here's the phone number and claim number and Power Torque's claim department from the O'Reilly's that he bought the motor from. And I have not heard back from him. I was the last one to correspond with him verbally or email wise.
Okay.
Until I sent a chattel link, and I thought he had abandoned the truck here because I didn't hear from him for like a year. So he abandoned it. So I sent a chattel link to him to get title on, so I at least get some cars out of my yard. And then I get a small claims court thing, sir.
Okay. All right. You're the plaintiff, Mr. Canada. You get the last word. Go ahead.
I had never contested that I would need to pay them and then address the warranty company on my own. That was never the concern. But I felt I made it very clear in my email to them that I expected them to make the repairs to make it safe and functional. So then at that point, I had an accurate representation of the cost associated with making that vehicle roadworthy to take to the warranty company. Until that repair is complete, I can't take anything to them. They're not going to warranty an engine that doesn't have a complete repair order attached to it. So,
All right.
I mean, that's where I'm at with it.
Okay. Well, this sort of goes in that category of cases I was talking about when I incurred settlement, which is, who has the high ground, who doesn't. That doesn't factor into my decision making. I have to look as to what's the legal point that's being raised here. This is essentially a breach of contract case. But the breach isn't negligence on the part of Interstate Auto or poor repair. The breach is it's taken too long and I still don't have an engine that works. But what really in my mind has occurred is that there's this, you each are speaking and you're speaking past each other. Mr. Stefan saying, I'm not going to put another dime into this vehicle until I get paid, and you start paying me, and then I'll keep, if you really want me to keep working, and I will, but you're going to have to keep paying me, and then good luck with the warrantor claim. And Mr. Canada says, how do I make a claim if I don't have a bill? Which is a reasonable approach as well. So you both are saying, each on behalf of your own position, but you haven't come to some agreement there. So in this case, since Mr. Canada is the plaintiff, the burden is on you, Mr. Canada, to prove your case. And even though you may prove that you believe you've communicated the best, that's not the legal issue. So I'm going to dismiss the case. There is no legal issue upon which I can find Interstate Auto liable for the claim that you've made. Now, where does that leave you all with? Interstate Auto has the truck. You just want to get a final bill. I suspect what you need to do is talk to Interstate Auto, have them do whatever they can to get the engine operable, and then you get a bill and you submit it to the claim. That's really all we're left with here. There is no legal claim upon which I can make a judgment at this point in this relationship. So I've signed a dismissal on the claim, and it'll be available to each of you in your file at the district court in small claims. All right. Thank you, gentlemen.
Thank you,
Thank
sir.
you for your time, sir.
Yep.
Wow.
Do you have any updates for me, Justin?
You know, the judge lets people go on a little bit, but then he really pounds it home when it means it. That was a big D there. Denied. I worked at
Hi,
a car
Denise.
dealership for a long time that had a, oh, hi, Judge. I don't know who Denise is. Hi, Denise. I'll just pause him for 1 second. Patrick, hello. I worked at a car dealership for a long time that had a like, and believe me, they're on you. Like a time to go without them checking in, like being listed about that. It was really, really weird. Like the work was not a lot of space usually in, well, car dealerships, different. Let's see what else the judge has to say. If you're just getting here, make sure you've clocked in for your shift by hitting that. Tell me what you have for dinner. If you didn't like what you have for dinner, tell me what you wish you had for dinner. And yeah, buckle up. It's Friday or Friday.
Okay. Yeah.
37294 was dismissed.
Right.
Parties.
What was that one you were mediating, Denise?
37247, I believe it was.
Okay. Well, good job. Looks like you got that one resolved.
That was a little bit of a wrestling match, but yes, I prevailed.
Yeah. They didn't know who they were messing with.
Right? Come on,
Yeah.
fellas, let's make an agreement. You never have to talk to each other again.
That's right. Well, I frankly had that marked as there was no way this was going to be resolved. So
Oh,
kudos to you.
awesome.
That was one I knew I was going to hear in trial.
Oh, shut your boost. I bet that fucking made her weekend. It doesn't even matter if it's true or not. I bet it's not. I'm gonna be honest with you. He doesn't make he's not the type of I just know he's just said that to boost her. I like it.
Awesome. Thank you, sir.
So yeah, that's the power of mediation right there.
Yeah, it does work, right? It's sometimes you're a referee and sometimes you just, try to get people to be nice to each other.
Yeah. Well, good job.
Thank you, sir. Have a nice day.
Yeah. You as well.
Bye.
Okay.
Yes, it looks like we still have two currently in mediation.
So 6 and 7.
Yes.
And all
That
right.
sounds good.
Where are we time wise? Either you or Kayla want to send a chat to them and let them know if either one of these are going to trial. We're going to need to start at at 11.
Okay.
Although suspect the last one to go in was number 7, so we could give them a little bit more time.
Judge,
Yeah,
what's
then
going
start
on with
with
these little murmurings? I really didn't think we had another
At least
case
there's
here,
number
but
6. Yeah,
well, it's an open court.
let them know.
Sherry?
can't listen to more than the breakout.
I have some Judge Anzalone too that I was going to listen to. The other
You
one,
can't message the mediator.
can you message the mediator and figure out if they're going to figure this out or not? What do you need to be, Judge? Do you have a lunch date? Oh, sounds delicious. I'm jealous. Oh, I was eating something. I was eating chips. Scroll through a little bit. I don't think. Yeah, see, he goes away. So let's just go ahead and get Judge Anzalone on here. Probably Creed frame. While that happens, just give me a minute. I'm back. Creed frame. Oh, homemade, 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 homemade clam linguine. Clam linguine. Love it. Saying it more times made it better. Hi, Judge. I think she was off for 2 weeks. This was her first day back.
Mr. Moore, are you here on the arraignment too?
For Walsh, I can handle whatever you need.
So this is in the matter of the people of the state of Michigan versus William Badger, file number 2021-20463FH. I have Douglas Hartung appearing on behalf of the people and Patrick O'Keefe appearing on behalf of the defendant. The defendant is requested to be in person and he is present in the courtroom. This is a date and time set for sentencing in this matter. I have received the defendant's sentencing memorandum as ordered and have had an opportunity to review that. Mr. Hartung, I have not received one from the people because we did receive this one late. Were you willing to proceed verbally today on the record, or do you wish an opportunity to file a written response?
I'm willing to go forward today, Your Honor. And also, I believe there's one individual going to Zoom in for this.
So they are not zoomed in. I have a note for them, but they have not zoomed in because I have.
They're gonna keep trying, I guess.
Okay.
Thank you.
Okay. If I do have a note about their.
Jim, thank you so much. I have a note about Jim right here. It says, thank you, Jim. Thank you, Jim. Sorry, all of the buttons. Look it up. Thank you so much, Jim. Oh, wait, did you do it again? You did. Oh, it's not Evelyn. My brain's seeing it properly. Ah, thank you. Get used to it. Get used to it, StreamYard. We press those buttons whenever we want. Like when Jim does that. Thank you so much, Jim. You guys are great. Yeah, we will never know. Did it cut? Oh no. Did it cut out when I was reading the note? Yeah, you'll never. It's a juicy note too. So juicy. Honestly, groundbreaking. Anyways, let's keep going. Can't tell you.
So okay, all right. So Mr. Badger, this is the date and time set for sentencing. Have you had an opportunity to read and review the pre-sentence report? Either this time or the last time?
Yes, Your Honor.
Okay, and have you had an opportunity to discuss that report with your attorney? I know you discussed it last time, and I know he spoke with you this morning. So have you had ample time to discuss that with your attorney?
Yes, Your Honor.
All right, are you satisfied with Mr. Mr. O'Keefe as your attorney and the advice that?
No, Your Honor, I feel like it was, excuse me. I wasn't represented properly. I think we covered, there were some things that were.
Hold on. I wish I was skipping like a carefree schoolgirl, Dawn. Stuttering, no offense. I'm just literally being like, he's actually stuttering to get this out. I'm going back because I wasn't listening because I was expecting him to just say yes. And so we gotta listen proper. We gotta listen proper to this guy go on about how he didn't do it.
With your attorney. I know you discussed it last time, and I know he spoke with you this morning. So have you had ample time to discuss that with your attorney?
Yes, Your Honor.
All right. Are you satisfied with Mr. O'Keefe as your attorney and the advice that?
No, Your Honor, I feel like it was, excuse me. I wasn't represented properly. I think we covered, there were some things that were covered and some things that weren't covered because of evidence. We didn't present our evidence, nor did we present witnesses that could collaborate some of the evidence that the prosecution had.
Okay.
So I just don't feel like he did a full. He did some, but it just doesn't feel like he did a full represented me. I'm trying to think of the legal term, but I can't at this moment. I just don't feel like I was properly represented.
Okay. And, but during the trial, you sat with your attorney, he met with you quite often. Like, met with you daily during the trial.
Yes, Your Honor.
And then you discussed strategies with him.
I didn't have any idea what direction we were going with this, Your Honor. Really, we started out with a strong avenue of what we're talking about in the beginning, and we said we had a case, and even when the offer was laid on the table for me taking a plea deal, he was like, we have a case. He goes, we've got a case.
You owe Mikey money if you say that, I think. Or is it? No, he's not saying we got a case, court watching. I'm just joking. If you know, you know. That's a throwback to another channel that I love to watch called We Got a Case. This is odd. I've never heard this. Like, I've heard them complain about their lawyer before trial, but this is after trial before sentencing. Interesting. Also, at the trial, my dude, I think she's gonna know if he was doing his best. What is broad reprieve? Is that oh, I need broad reprieve from street. I think he means reprieve. Oh, wow. If it makes you feel any better, a little further. But is a fickle master. All right, let's keep going. It just keeps picking me up.
So being him, like, I looked at it like, well, if we got something, then I'm willing to go that direction. So I have no idea. So I listened to what my counsel had to say. I paid him in full of what was supposed to be done. And this is where we're at today.
Wow. Yeah, you were convicted by a jury.
Yes,
all
ma'am.
right, Mr. Hartung, is there any response to that statement? I'll allow Mr. O'Keefe to speak as well.
Okay. Well, first of all, 94 days ago, this was all fine. who were good that day. He said everything that Mr. O'Keefe did was perfect for him, was fine, he was well represented. Mr. O'Keefe did an outstanding job representing this defendant.
Now the the prosecutor is in the loud. Thank you. And we tithed to the thing. It might be YouTube daddy fucking it up. He's like, you talking about me. Thank you so much though, seriously. But I'm not kidding. Now the prosecutor's in the weird position of having to defend me about beating him in the case, which is so odd. Like, oh no, we fought fair. Like, it's a weird position to be in, you know? He has to defend the defeat and say, no, everything was good enough. But like, I don't know, it's a hard thing to have to explain to the dude. It's like, dude, what I happen to think is that he was probably guilty as. Actually, he's convicted now, so it's not even allegedly, but guilty as fuck might have had something to do with it. And then the judge knows it, the prosecutor knows it, YouTube daddy knows it. You know what I mean? Strawberry moon. I'd like some strawberries, sour cream, and brown sugar.
He started, and every time we had a pretrial, we put on the record, he had an opportunity to plead to this particular plea bargain. And every single time he said it, he didn't want to do that. Even right before the trial began, that was all placed on the record. He said he didn't want to do it. During the course of the trial, he and Mr. O'Keefe met and talked, and they made a decision that they placed on the record that he did not want to testify. And he was comfortable with that, and he made that decision that day, or probably prior to that day, to put the information on the record that day. There's absolutely no basis whatsoever. Mr. O'Keefe did an outstanding job.
Mr. O'Keefe, do you wish to respond?
Briefly, Your Honor, this is the first I've heard this from my client, and I'm not going to stand here and attempt to defend myself because I'm confident that I represented him to the best of my abilities. I'm confident that I was effective as his attorney. Given that this is new territory for me, this is the first time I've heard my client say anything about my being ineffective. Now, he has expressed some buyer's remorse about the trial and about the verdict, and it sounds like that's what we're dealing with here. But if it's something that's more technical than that, I'm questioning whether I should go forward as his attorney. If he doesn't have confidence in me now, I can't imagine that he would have confidence in me going forward with the sentence.
Well, what I would say on the record is that I always very studiously put plea agreements on the record and ramifications of plea agreements almost ad nauseum, because I was a former defense attorney and I know that people sometimes do not understand the ramifications of a conviction or a plea. So I think that you knowingly went into a trial knowing what the plea offer was. Both attorneys, Mr. Hartung and Mr. O'Keefe, were exceptionally prepared and studious during this trial. And so, Mr. Badger, your proposed dissatisfaction with your attorney is something you would deal with on appeal. So, Mr. Badger, do you want to proceed to sentencing with Mr. O'Keefe today and let him argue his sentencing memorandum?
I feel confident in his arguments, Your Honor. I just don't feel confident that in the trial, during the trial, the things that were needed to become out, my witnesses, we didn't pull the witnesses.
Okay, well, that's
sorry. Yes, Your Honor. I wish for him to allow to move forward.
okay. So, Mr. O'Keefe, you provided to the court a sentencing memorandum that went into great length, your request regarding the sentencing guidelines. So I'm not going to start with that first. So the first thing I would ask, Mr. Badger, as I said, you read the pre-sentence report, correct?
We went over it together,
Yes.
the lawyer and I, yes.
All right. Do you wish to explain or challenge the accuracy or relevancy of any information in that report regarding your family, your background, your history, your medical history, financial history?
No, Your Honor, the financial history was, everything got paid off through
No, I'm just saying, is
No.
the document, was the information about your background correct?
yes.
Okay. Now, I understand there is a statement taken from the police report in that pre-sentence report detailing the incident as reported in the police report. And you may agree or disagree with some of that. But in terms of any other information in the report, do you wish to explain or challenge that?
I didn't quite understand what you're saying. Your
Okay,
Honor.
so you read the pre-sentence report, right?
Yes.
Okay, and in that pre-sentence report, you know, there's an evaluation and plan that talks about you, additional information. No?
No.
I have a Haley Toms in jail room 6.
Okay, thank you.
Do you want my Zoom number again?
I can resend it.
Okay. I mean, he may be connecting, he's just not popped into my waiting room yet. So in that report, there's a victim impact statement. There is a summary of the police report, your lack of prior record, family information, marriage information, employment, education, substance abuse, health, and finance. So Mr. O'Keefe, I know that you had an opportunity to speak with him about that. Do you wish to explain or challenge the accuracy or relevancy of any of that information?
Well, there's just a couple of factual corrections, Your Honor. On page 9 of the PSR, it indicates that Mr. Badger has an asset in his house worth $135,000. I'm not sure if this matters to the Department of Corrections, which is why I raise it now. Mr. Badger's informed me that he sold that home. Is that correct, sir?
You're correct.
And then beneath that, with respect to his liabilities, it indicates a mortgage of $59,000. And I believe that mortgage has been discharged through the sale of the house.
Okay.
Is that correct, Mr. Badger?
You're correct.
All right. So aside from that, Your Honor, we don't have any.
So, Mr. Moore, can we just add a sentence that at the time of sentencing, this debt was discharged and the home was sold?
Yes, I was going to add, Your Honor, just to remind the court, when we were in here last time, I did make a change to his medical to March 2021, which will reflect it in his information with the Department of Corrections. And also, I thought, so the home sold for $147,000 on April 4th, and I thought I would put that in as a sentence below because at the time of the PSI, he did own the home and have the mortgage, so I can add that sentence on there.
Okay. Mr. Moore was referencing under health. The last time we were here, you had made a correction. Treatment date was not 2024 on those two issues. It was 2021, and that's been marked.
Correct. Thank you, Your Honor.
Okay. And he has no prior convictions, really. So now we move on to your sentencing memorandum.
Your Honor, we have an issue with the jail credit as well.
Yeah, we'll update that too.
Okay.
Yeah. What's the updated jail credit now, Mr. Moore?
Go ahead. I'll get that figured out real quick.
It's 94 additional days.
94 additional days.
Okay.
So. 170. So we'll make that 170 days. Thank you, Mr. O'Keefe. All right. So let's move on to the sentencing memorandum. So Mr. O'Keefe, you may proceed on that.
Thanks, Your Honor. And I apologize to the court and to the people for the late submission. This snuck up on me, so I apologize. I should have had this on my calendar to submit sooner to give Mr. Hartime an opportunity to respond. But nonetheless, I felt it was important to at least place the objections in writing and make them part of the record before we proceed to sentencing. The defendant has an objection to scoring a PRV 7 as was indicated in the sentencing memorandum, without going into a whole lot of detail, I know the court's read the memorandum. We would object to scoring PRV 7 at 10 points. I realize that the court is more or less constrained to score the highest number of points. However, I wanted to place on the record a constitutional challenge rather than a discretionary challenge. I know the court doesn't have discretion, but you know, it's always struck me as a little bit odd when you have an incident that involves two separate offenses that's part of the same series of conduct, that you could score that as part of a person's prior record. You know, we deal with PRVs a lot in this business, and the word prior is antithetical to what is indicated in PRV 7, which is subsequent or concurrent felony convictions. So I'm not asking the court to make a discretionary change in that guideline, but I do want to make a constitutional challenge on the grounds that would be considered extra punishment for the same conduct. And so you need me to move this mic closer. So I should have been watching her in front. But, you know, so we would object to that on constitutional grounds. And then the other challenge was to offense variable 18, which is scored at 15 points. And that's based on the defendant's blood alcohol content at the time of the offense. Again, I think the court has to score the highest number of points for this variable. And if in fact the blood alcohol reading that was tested by the hospital and determined by the hospital to be 0.18 would certainly be deserving of 15 points if it in fact is accurate. We scheduled a Daubert hearing. The court ruled against us in that respect as far as the scientific validity of that reading and moreover the forensic validity of that reading, given that it's not a forensic blood alcohol content. I would ask that be scored lower because I believe there was really no testimony that machine was in good working order. I know there were several people that testified about that machine in terms of generalities, but certainly nothing that would even approach the realm of a forensic blood alcohol content, which is what the law requires people to prove, is that the defendant's forensic blood alcohol content, his legal blood alcohol content was at or above a 0.08. So we would object on the grounds of 15 points, or ask the court to score that at 5 points, given that there is some evidence that there was alcohol consumed prior to driving. Aside from that, Your Honor, notwithstanding the constitutional challenges or the challenges to guidelines, as I indicated, if the defendant were only convicted of one of these felonies, had he only been charged with one of these felonies, certainly the people can sustain multiple convictions. Mr. Hartung has briefed that. We've stipulated that the court can, in fact, and should, in fact, score the defendant the highest number of points that they can sustain a conviction, a concurrent conviction for both reckless driving causing death and operating while intoxicated causing death.
Causing death. Wow. You'd think I'd learn my lesson, hey? This is a good reminder not to drink and drive, and also don't court without looking at it first now. So it sounds like a DUI with the death. Yeah.
I'm not challenging the court's ability or the court's duty to actually impose a sentence that would be concurrent with each conviction, but rather I'm just trying to point out the fact that we're not for the second felony conviction, and I'm not sure there's really any way to sort of parse out which portion of the defendant's activity or conduct was reckless and which portion was owing to the fact that he was intoxicated Notwithstanding all that, if he were convicted of one felony here, the prior record variables would have been 0, and the guidelines would have been 1938 months. And so we have, as a result of the multiple convictions, notwithstanding the constitutional challenges for essentially the same series of conduct, we have an elevation in the guidelines from 19 to 36 months, 19 to 38 months. We go up to 36 to 71 months. So it almost doubles the guidelines in that respect. I know the recommendation is fair. It's within guidelines. The Department of Corrections is recommending a sentence of 46 months, which would be within the guidelines as scored currently. I'm just simply asking the court to consider a downward variance from the guidelines in light of the inflation in the guidelines, in light of the defendant's acceptance of responsibility, and in light of all the circumstances that surround the defendant's history. Thank you, Your Honor.
Thank you, Mr. O'Keefe. Mr. Hartung?
Your Honor, I received the memorandum on Monday, and I called or got a hold of Mr. Moore shortly thereafter. Told him that in case the court wanted to ask him any questions about how he scored the guidelines, he should be prepared. But as it relates to PRV 7 first, the PRV is very clear on the concept that 10 points are scored for one subsequent or concurrent felony conviction. It's very clear. I understand the objection here, but I don't think there's any case law on that issue. But I would point to the analogous case that we talked about a bit at the time of the trial, which is People versus Friedel, which is 340 Mich. Act 221, that in detail outlined the concept that someone could be convicted of both reckless driving causing death and OWI cause.
He's doing exactly what the defendant falsely having his back, trying his best, and doing a good job. It's actually like saddest part. We don't often hear them. Interesting. Let's keep. We're gonna hear what happens.
Manslaughter out of those same factual circumstances. And because of that, I think this is an appropriately scored PRV number for the court to consider. I think Mr. Moore scored that correctly.
And hacks, your work has been interfering with your court watching. I get it. But I'm so glad you're here. We missed you. Yay! Thank you. Thank you. Thank you. Do. Yay! Cheery case for you to come back. I'm just joking. Thank you so much for being here. Reminder, we had a really funny members only last week that I'm still laughing about. Chicken ambulance. And we got something good coming up for this members only on Sunday. It's gonna be awesome. It's gonna be great. Thank you again. We got her pondering face on. She's like,
OB 18 rather. We did have an evidentiary hearing. We went through that in some detail. We did it again at the trial. I believe the court ruled correctly and the jury found the defendant guilty of the OWI. There, we had testimony from numerous people that were involved in the taking of that blood, nurses, phlebotomists, runners, blood techs, lab techs. We even had testimony from doctors and a scribe who's now a doctor. And they were very, very comfortable with the idea that this was an accurate number. And the court ruled that it could be admitted into evidence. And the jury was able to read that evidence and to show that his blood alcohol level was 0.18 at the time that it was taken at the hospital there. And I do believe that OB 18 is scored properly as well, Your Honor. I think we comply with all the statutory requirements of getting that information in, both in the evidentiary hearing and the trial. as well as the case law. I believe it's People versus Courts that talks about that in some detail and was noted in our evidentiary brief. Thank you.
Any response, Mr. O'Keefe?
No, Your Honor.
So the court does appreciate the constitutional argument that Mr. O'Keefe has placed on the record, but obviously I do not change law. I only enforce the law as it is written. So with regard to PRV 7, that is not discretionary. The court must score the appropriate point value if the offender was convicted of multiple felony counts or was convicted. In this case, he was convicted of multiple felony counts. That does not result in a mandatory consecutive sentence. So the court in this case must score that, and it is properly scored at 10 points. The objection to OV 18, again, there is no discretion on whether or not the court can score that, and so the court does find that it was properly scored. Of note, there is an interesting case out there involving actually a minor, but in that case, People v. McGee, which is a Court of Appeals unpublished case issued January 13th of 2009, docket number 280534. They said that the court did not err in assessing points of an underage drinker at the time of the offense because MCL 777.481D does not limit the proof for an underage drinker in that case to just scientific measurement. So testimony as well. But we did hold a hearing, and we did have probably half a day or more of testimony from the individuals working in the hospital about the way that blood is taken, sent, tested, chain of custody. So the court does find that it has no discretion, and OV 18 is properly scored. So with your objections on the record, Mr. O'Keefe, I still have to score those, and the court finds that the guideline minimum range is 36 to 71. Notwithstanding your objections, do you agree that that was properly calculated in terms of adding up the numbers?
Yes, Your Honor.
Okay, thank you. Before the court passes sentence, I would ask that you have a seat over here because I believe we have some people who wish to speak.
We do not, Your Honor.
No one wishes to speak.
No one's going to speak.
All right, so Mr. O'Keefe and Mr. Hartung, can you approach over here?
Yeah, I think that, oh, are they whispering? They're having a little sidebar? Okay, well, I think you're right. And I think that recklessness and alcohol go hand in hand. What's happening?
Thank you. I just appreciate it. Sure. All right, thank you. Okay. All right. So that being said, Mr. Hartung,
Oh shit! Guess what? Streamlabs, get off my lawn. Sidebar is like what I remember almost the most from the Casey Anthony trial. I watched that entire trial live over the internet. It was my first ever. And the sidebars were nuts. And what a crazy case to watching like live court because I was addicted from the early. Only luckily lately I've been able to find a good source for my court.
Recommendation in this case is for a sentence of back there.
Bill, I was thinking that she was saying there is the victim or some victim in the courtroom. And I think make sure, hey, are you sure that this person doesn't want to come up and testify?
3 years, 10 months to 15 years with credit for 170 days already served. So do the people have anything they wish to place on the record?
Yes, Your Honor, could I use the podium?
Yeah, can you guys step over there and let Mr. Hudson use the podium? Thank you.
Your Honor, I'm going to advocate today for a sentence of 54 to 180 months, and I'm going to explain that. But first, I want to thank some people. This case has been going on since May 30th of 2021, and it's been a long, long endeavor to get to the point where we are today. I want to really thank the entire Campbell family for their hanging in there, for one thing, while this was going on. It's taken a long while to get to this point in time, and they've been very cooperative throughout. Karen Campbell wrote an absolutely amazing victims impact statement. I can't say it anywhere near as well as she has put that as to the impact that this has had on her family and the nature of her husband as well. I want to thank Bill Warner. I want to thank Kevin Greca and Keith Thorney for their help from the Sheriff's Department. Also Austin Hall, who is no longer with the Sheriff's Department, but testified during the trial. I'd like to thank all of the people at Toledo Hospital and the EMTs at Riga and Blissfield Fire Department for their assistance and help throughout this matter. Doctors, scribes, phlebotomists, med techs, lab techs, runners, nurses, many of whom remembered this incident years after the fact and testified very acutely as to what they recalled and what they did and the impact that this had on them as well as the staff attorney at Toledo Hospital, who did a great job arranging that all to come in. And these people all appeared voluntarily, essentially. So most of them coming from out of state and some of them coming from as far as, I think, Alabama or Florida. I want to thank the people of my staff, Kristen and Sarah, who helped in the courtroom and helped outside the courtroom to keep this going for 3 years. And I want to say some things about David Campbell.
Dramatic pause. Is David Campbell the person that died? That's very sad. That's really sad. F in the chat for David Campbell. Well, let's wait and make sure that's the one that died. I only want to do one F in the chat.
I never met him, but through this whole thing, I got to know him pretty well, I feel. And excuse me, he is quite a man. And he's 78 years old at the time of this incident. He's kind of the cool old dude in the neighborhood. Everybody's got that guy. He's the guy who walks his dog, says hello to everybody in the neighborhood. Nods hi, how you doing? Always has extra beer in his fridge for a buddy that stops over. Always wears a cool hat. And I kind of got a feeling about him throughout this whole trial from his family, from the pictures, from everything else I got to see. He kind of reminds me of my father. I'll bet he reminds a lot of people of their father and a lot of people about their grandpa. And he was 78 years old at the time that this happened. He had a life expectancy under most actuarial projections of another 9 years. And I want to talk a little bit about the request by the defense and their memorandum for a downward departure from the guidelines. I think it's not appropriate. It's not an appropriate nature in this case to go above the guidelines. It's not appropriate to go below the guidelines. It's appropriate for a sentence within the guidelines. There's some discussion about the defendant taking responsibility from this, and he did initially. Yeah, but as you recall during the testimony, he started to back away from this. And he told some things that weren't true to Mrs. Campbell about how the accident occurred, how about that the vehicle just slipped backwards into the ditch, which wasn't accurate at all. And when she said to him, you know, Bill, your blood alcohol is, you know, pretty high, it's 0.18. What about that? And you remember what he said, what she said he said about that? He said, make them earn it. I'm gonna make them earn it. Well, the people at Toledo Hospital and the nurses, all the people involved in that, and the lab techs, and all the people we've talked about, did a great job. The court entered that testimony, evidence, the jury considered it. They earned it. We earned the conviction. So the additional 9 years of life likely taken away from him, and that's 108 months. That's way outside the guidelines.
Are they what the old dude would have had left? I've never heard that approach before. Wow.
It's not proportional under People versus Milborn, the old case, or the newer case, People versus Posey. But I do think that 54 months is half of that 108 month total. And I do think that's a fair number to look at in consideration for the sentence here. The idea that half of his life is gone because of what happened here is an interesting concept to consider. I think it's appropriate from a proportional standpoint. It's appropriate from the standpoint of deterrence, punishment, all the key factors, I think, and it's right in the middle of the guidelines, as it turns out. This is a number that's smack dab right in the middle of the guidelines. So I'm advocating today for 54 to 180 months as a sentence. Thank you.
Thank you, Mr. Hartman. All right, so if you would stand back up at the podium, please. Right, Mr. Badger, you can come stand next to your attorney. Now, I'll start with you, Mr. O'Keefe. Is there anything you'd like to say on behalf of Mr. Badger?
Yes, Your Honor, I just want to remind the court as to why I think there was a recommendation at the lower end of the guidelines. I think the Department of Corrections correctly recognized that my client has served his country. Up until now, he has had no prior.
Oh no, that sucks, Sean. Also, did he just slip in his military service? But the thing is, you can get away with, I've not ever had any, but not when you've taken somebody's life. It's like YouTube Daddy or StreamYard. Whichever daddy isn't holding up his end of the bargain with my streaming. It's like he knows. Hey.
No convictions whatsoever. The pre-sentence report even indicates that the last time he consumed alcohol was the time of this offense. And so I think at worst case scenario, I think the recommendation should be followed, that being 46 months. I don't believe that there's reason to go above that, but I do think there is reason to go below that, and I've stated that earlier. So I would ask the court to sentence Mr. Badger accordingly.
Mr. Badger, is there anything you'd like to say on your own behalf before the court passes the sentence?
I'm sorry to the family for what happened today. If I could take it back, I would. If I could pick this place, I would. I still have nightmares over it. I dream of it every day, and no matter what you lay on me with the sentence, I'll forever live with this the rest of my life. And I am so sorry. I am terribly sorry to the family. That's all I can say, Your Honor.
Yep.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. I was trying to put my hands on, when I reviewed the statements, because there's so many statements for both sides. There was a statement, I believe by you, Mr. Badger, that was contained. Let's see if I can find it. But I can't put my hands on it. But to summarize, in addition to what you said on the record, you stated that he was your friend. And to this day, you regret your actions and the loss of your friend, and that you did that. So the court just wanted to place that on the record as well. So it is a sentence of the court that you will serve a period of 54 months to 15 years with Michigan Department of Corrections. We'll give you credit for time served that was calculated at 170 days. You will pay $68 in state costs for each count and $130 crime victim rights fee. There is a $60 DNA fee. Now you do have, Mr. Moore, is there anything else to add?
So it's 54 to 15 years on each count, correct? And they'll run concurrent?
Yes, I'm sorry. Yes, 54 to 15 on each count.
And then they'll run concurrent, Your Honor?
Yes, may run concurrent, not consecutive. I think the guidelines were the same. Yeah. All right, anything else, Mr. Moore?
So that's 4.5 to 15 years. I guess they count it in months, like a reverse version of why parents, like what parents do with young children, cling on to. I don't know. 4.5 years to, but no, it's concurrent, which means it runs at the same StreamYard. Consecutive means one after current means at the same time.
No, I think that's it, Your Honor.
Now, Mr. Badger, you do have the right to appeal the sentence. So bailiff's going to bring down to you your notice of right to appellate review. You need to initial and date a copy that is held separately. Yeah, and that's for my records, just to acknowledge you received the paperwork. The other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form. You can do it one of 2 ways. You can do it today. You can sit down and do it today, or you can do it at the jail, or you can do it at RGC and get it back to us within 42 days. All right.
I can do it here, Your Honor.
Yep. Have a seat.
Is it possible to get a court-appointed
No,
appellate lawyer?
we go through that. Not today. No,
Yeah.
no. You don't have to do the bottom part. So if you want to have a seat, if you can, I don't know what's easier, but he has to fill out, he doesn't initial and date it. He has to fill out the bottom part.
I'll fill it out later, Your Honor.
No, take your time. You can do it. Now, anything else, Mr. Hartung, Mr. Hartung, and Mr. O'Keefe?
No, thank you, Your Honor.
Thank you.
Your Honor, thank you.
Okay.
My client's acknowledged receipt of the form, Your Honor. I'm handing him, there's 2 copies. Does he just need one? Or do we fill them both out?
I think he fills them both out. I don't know if he's qualified for court-appointed counsel because if he has assets from the sale of the home.
Yeah, he just sold that house and he has all that Skrilla. I was just thinking that. I was like, he's not going to qualify for the court-appointed attorney when he's got all that money in his bank account. Would have been not taking that. I don't know what to do. I don't want to help the criminal.
Yeah, you can fill that out.
All right.
But you do have assets, so you'll have to fill that in, okay? All right, thank you. And if you do it at the jail, they'll send it over to me in a kite. Records should reflect, I received that and signed a copy of the notice of right
Oh,
to.
they could do that quickly, hey? MB, maybe they should do that quickly and then recover it. I've heard some places want money in a commissary.
All right, so Mr. Mont, you got someone standing next to you? Oh, no, okay. All right, let's see, I got the jail. I have an arraignment, I believe Rhonda Underwood's on that arraignment.
That hair, there's the bad, that's such a bad look, bud. I think I don't think
Benjamin Klein, Miss Adams was.
I think it's a like tragic hairline, if I'm being honest. Hi, Hector.
Was Benjamin Klein adjourned?
No, at this time it is at 3:30 this afternoon.
Oh, I kept trying to figure out why, okay. All right, in the matter of the people of the state of Michigan versus Jonathan Jones, file number 24-21842FH. Rhonda Underwood is on that file and I do not see her, but I also do not see Mr. Jones. Who do I have from the jail?
Casey McKenzie.
All right, Mr. McKenzie, you're also.
Did he just say Tennessee Mackenzie? That is quite the name. Imagine entering kindergarten as Tennessee Mackenzie, having to learn.
Run. So just bear with us for a moment, Mr. McKenzie, all right?
All right, thank you.
Okay. What do you have, Mr. Mott? You have Miss Butler, right?
Yes. I'm assuming we'll just set for evidence here.
I don't know. Is Mr. Sala on the other side?
I thought so.
Why don't you come up to the podium?
It's growing on me.
All right, I have somebody logged on as Haley Toms. Are you Scott Toms?
Yes, ma'am.
Okay, this is in the matter of Angela Caitlin Butler versus Scott Toms, file number 2011-36187DP. I have Katerina DeMont appearing on behalf of Miss Butler. Mr. Toms, do you have an attorney?
I was going to ask for a continuance.
Okay, you're asking, and Miss DeMont is probably had stated earlier that she thought we were going to be asking for an evidentiary hearing today to take testimony. So, Mr. Toms, are you going to hire an attorney?
Yes, ma'am. I still haven't received Mrs. Butler's paperwork.
Your Honor, I'm not sure what paperwork he's.
What paperwork are you talking about?
To my knowledge, our last hearing, Mrs. Butler had asked for a continuance because she had not had enough time for a rebuttal.
Your Honor, I filed that. When I spoke with Mr. Sala's staff, they said that they were going to be retained on that. So I proved it to his attorney. I don't have.
Okay, so Mr. Mont did file a response and talked to Mr. Sala's staff, and Mr. Sala said he was going to be retained. So she had provided a copy to Mr. Sala. So what I'm going to do is I'm going to, Mr. Toms, are you willing to accept it via email?
Yes, Your Honor.
All right, do you have Mr. Toms' email?
No.
Mr. Toms, what is your email?
That would be
So give me the letters. Is it H-H-E? And then what was the number?
That would be 495 at G.
All right, so H Henderson, H.
Judge, you fucking bitch. No, you know what I mean.
Yes, Your Honor.
Okay, good. So Ms. Demont will forward to you a copy that she provided what we thought was your attorney at the time. And Miss Adams, I need about, well, you can bring me the book or you can.
Yeah, I'll bring you the book.
Okay.
Judge, are we gonna hear my show cause at that time too, when you adjourn it?
Yep. All right, because summer break has already started, we need to do this very quickly. So. I can do 1:30, June 27th.
That's
These
good for
have
me.
to be, okay, all right, so 1:30, June 27. And Mr. Toms, I'm assuming you want Zoom?
Yes, Your Honor.
All right, are you available? I have to hear this within so many days, that's like.
Yes, Your Honor, I'll
Okay.
figure it out.
You are wonderful. All right, so both of you, thank you so much for working with me on this. So we will see you back here on Thursday, June 27 at 1:30. I'll have you scheduled for 2 hours. Mr. Toms, who are your do you have any witnesses you're going to be calling?
My wife, Haley.
Okay, anybody else?
My younger sister, Alicia.
All right. Anybody else?
I believe that's it.
My two
Okay,
bitches.
And Miss Dumont, do you have any witnesses you're going to be calling?
We would call Miss Butler. And that would be it.
Okay, and their only witness would be Miss Butler or perhaps yourself. All right, sir?
Yes, Your Honor. Could I also include my father-in-law,
Sure.
Larry Henderson?
What's his name?
His name is Larry Henderson.
Larry Henderson. All right, are you going to be presenting any documents, Mr. Thomas?
I do not believe so. Everything should already be submitted.
Okay. All right, so Ms. Demont is going to email that to you today. I need you, when you receive that email, to respond received, okay? So that she knows that you received it.
Yes, Your Honor.
Okay, very good. All right, so we will see you back Thursday, June 27th at 1:30 p.m. Thank you.
Yes, Your Honor. Thank you.
We will be
Thank you
later. Did he just
All
brush his
right,
tears, you
Ms.
guys?
Underwood, and okay, so Ms. Underwood, couple things.
Pretty sure he
I have KC McKenzie. So this is in the matter of the people of the state.
Oh, it's KC McKenzie, not Tennessee McKenzie. Tennessee McKenzie was really growing on me. Tennessee McKenzie, get your ass over here. Yeah. My internet moves don't like it, but yeah, and respond didn't receive if you didn't.
Michigan, Phil McKenzie, file number 23-21324FH. Mr. McKenzie is represented by Rhonda Underwood. This is a date and time scheduled for a probation violation hearing. Miss Underwood, how would you like to proceed today on behalf of Mr. McKenzie?
Your Honor, can I just have a very brief, and I stress brief minute with Mr. McKenzie?
Okay, so before I do that though, Ms. Underwood, I'm going to call in the matter of people of the state of Michigan versus Jonathan Jones. File number 24-21842FH. Deputy Gorney, we do not have MDOC here, correct?
No.
Yeah, so MDOC is neither zoomed in nor appeared today, Miss Underwood. I don't know if the people did a writ. I don't know if you filed a waiver.
I did not file a waiver, Your Honor.
All right, so we will, Miss Adams, I have the book. So what I'm gonna do is set this over to I'm going to set this over to July. Oh, no. Becky's gone.
Congrats. I was thinking
I'm
about
gonna
you the
set
other
this
day.
over to, not gonna
What
do
do you
that
think
either.
about
Hold on.
Tennessee Mackenzie as a name for a future country star?
Well, I'm gonna do July
See
10th for
Mackenzie.
arraignment. July 10th
All right.
for arraignment, and the people will do a writ and we'll do the notice of hearing. All right?
Ms.
Yes,
Underwood,
Your
did you receive the amended information in this matter? Can you check that for us? And if you didn't get it, oh, excuse me, the one with the supplements on it.
I do not have the one with the supplements on it.
Okay.
Judge, it was emailed to Ms. Adams. Someone from our office was supposed to bring copies up here. I see that didn't.
Okay, so no, if you email it to Ms. Adams, it doesn't get filed.
Right, I understand it.
So I have a copy of it, but it's gotta be filed.
I understand. We get that filed today, but if we could arraign him on that one.
Okay, I'll have it in my file by then, so thank you. All right, so, yeah, all right, so I'll set this over, like I said, to July 10 at 8:15 in the morning.
After both of our countries.
And anything else you need to address on that, Ms. Underwood?
Canada Day, July 1st, and
Yes, Your
America
Honor,
Day.
thank you.
Or what do you call it?
Okay, all right, so we'll see you back July 10 at 8:15.
July 4th.
Sorry about all the confusion. Thank you all.
No worries, Judge.
All right, now I'm gonna open up a breakout room, Mr. McKenzie, and pop you and Miss Underwood into it. Underwood. Okay, there we
July
go.
the 1st is Canada Day. I think, oh, it's Independence Day, but you call it July 4th, right? Yeah. July the 1st is Canada Day, and say that, by the way.
So,
no, Judge, I'm gonna be serious because when you say Canada Day, there's this really quick, like triple D, not the Food Network show, but sort of like a thing that happens in your that I once noticed and never was this afterwards. Canada Day, Canada Day, Canada Day. It's so fun. Try it.
Mr. Daly and Miss Arnold, have you had an opportunity to go through the final jury instructions?
Judge, we have one issue. Our next witness is one of Rihanna's siblings, and her mother got pulled over for speeding. So we're trying to get them to release her and figure out how far away she is. So we did go over the jury instructions, so.
Okay, but the jury instructions, no objections or anything you need to add?
3.3, I've got a note for the court. 3.3, the defendant not testifying. Jim said he is going to testify. And then 20.13, we had that issue that the word touch wasn't on it. I emailed it to you, Sierra, and Becky, and Sierra said she got it. So we need to substitute that.
So we're taking out the one about defendant not testifying?
Yeah, I've got this. And then we got a substitute 20.13.
And that's been put in there yet? No.
Ms. McGrain should have it. She didn't, I had it with me, so she hasn't put it in there yet.
Do you have it?
I emailed it to.
I thought you said you have it with me. Oh, the book.
Right.
I drink Canada Dry, Canada Dry. Oh, look, Canada Dry. But we wouldn't call that here.
Today you
I would
emailed it
just call it ginger. Canada Dry.
Oh.
Canada Day. Interesting. But no, like I do drink Canada. That's so funny. I do drink, but I would only call it ginger ale in my head or out loud. Like I would say that I would never once offer somebody a Canada Dry. I would say,
Stick it in there.
do you want a ginger ale? And they would say yes or no.
Mr. Daly and Ms. Demont, have you had time, did you need to speak with your client? Has everybody accommodated you on that? Okay. Bruce.
Here's my ginger ale. Close. They do. I don't know. I don't drink tonic water usually.
Right, so I've replaced 20.13. Look.
It's hot now. Yeah. It gets warmer here in the evening again because we have no AC. So. And of course
Ms. Underwood, you are back. Let me close that breakout room.
Thank fuck. And Miss Underwood, could you fix your camera, please? You've got more of the back wall than your face.
All right, so Miss Underwood, you now had a chance to speak with Mr. McKenzie.
Yes, Your Honor. I discussed this matter with Mr. McKenzie. Mr. McKenzie has other files open, Your Honor, with Mr. Malero that I believe are scheduled for trial in September. Mr. McKenzie at this time would request a brief adjournment so that we can figure out how best to proceed so that these matters can be resolved successfully, Your Honor.
Is she even talking? Is this an AI?
How long would you like an adjournment?
2 weeks.
Sounds like terrible AI. 2 weeks. Yeah, Australia's in winter time
So
right
July 3rd.
Oh,
That's
that's right
fine,
in
Your
between
Honor.
the birthdays, guys. Canada
And it's
Day.
about, so we'll do the notice of hearing. So we'll set this over to July 3rd at 8:30.
Like if somebody was like, oh, okay, we're gonna schedule that for June 30th, everyone would be like, isn't that the Canada Day weekend or like holiday? Like you just everything gets a buffer. That's how we make the year go by.
In the morning, and we'll see back on that day, Mr. McKenzie. All right, I'll continue your not guilty plea.
Thank you, Your Honor.
Oh, Mr. McKenzie, you are muted. So why don't you unmute your device?
Is that good?
Yeah, what were you saying? You were saying something.
I've been in jail since January 3rd. I have a home invasion and 3 felony firearm possessions. I've been to court downstairs about 5 times. I've stressed the issue every time I've wanted a trial within 180 days. And if I gave up my right at any time that I was ill-advised by my lawyer, I wanted it in 180 days. I didn't have my proven for almost 100 days because they kept messing up on my writ from another county jail. My lawyer won't come see me. I let him waive arraignment in circuit court.
So, Mr. McKenzie, the only thing I have this morning is this violation of probation. I don't have your other files. I don't have the attorney or a prosecutor present on it. So I'm gonna set this over for 2 weeks, okay?
So who do I talk to? Because my next court date for that's not till September 22nd. And I can't get a hold of my lawyer and he won't come see me. So that's a problem.
Miss Underwood will send a note to your attorney that you want to speak with them. All right?
All right.
All right. Thank you, Mr.
Thank you, Your Honor.
McKenzie.
Yeah.
Thank you.
Judge, are you doing this car at another time?
Am I doing what?
Aaron Carr was picked up.
I don't have time to do my pickups this morning. I'll probably try to do them this afternoon or after my jury goes into deliberations.
Okay, will you just text, will you
Is
just
that
text
the
me?
case with Hannah Walt as well, Your Honor?
Yeah, I have to get back to my trial. So Hannah Walt and Carr will be sometime today, but I don't know when.
All right, you'll text me.
All right. We'll let
Thank
you
you,
guys know. Thanks. Bye.
Wow. Look at her humble bragging about having a trial. I love it. I love all of you, as a matter of fact. What a lovely evening we've had. It is still, what is it? It's 8 o'clock. It's 8 o'clock on a Friday night, a FriYAY night. I would like to say thank you again to everybody for being here, everyone who sent donos, everyone who just sent comments, who didn't send a comment, who lurked, and for the like 3 people that hit the dislike button. I just want you to know that I love you extra. I love you. And that goes for each and every one of you. I love you. I am proud of you. And I will see you in the next video. Bye.